Hello, and you're welcome to episode 56 of The Fifth Court, a podcast on legal affairs presented by myself, Peter Leonard, barrister.
And myself, Mark Tottenham, barrister and editor of Decisive Law Reports.
Mark, good to see you as always. And you will recall that last week, or thereabouts last week, it was kind of the Christmas festive period. So I think there was maybe 10 days. I know somebody gave out to me because they said, you always produce a weekly podcast. And it was about 10 days. So there you go.
People do like to listen to The Fifth Court over their Christmas break, as we've discovered from our Twitter feed. What else would you be doing?
Absolutely. But we had a fascinating discussion with Mark Garrett, who is now 2 years into his role as Director General of the Law Society. On one level, these are the best of times for the Law Society because there's loads and loads more solicitors. I mean, there's been an exponential growth in the number of solicitors, but that is causing other problems.
Yeah, and I think the interesting thing is just the small family firms, the high street, small town firms that people go into for their ordinary legal representation. A lot of those are run by people who are, should we say, moving into the second or the later part of their career, and they don't have people coming up to succeed them because they tend to be going into the larger commercial firms. And as Mark Garrett rightly pointed out, this is an issue that affects not just the law, it affects the medical profession.
Yeah, but he was very clear he didn't want to pit one lawyer against another sort of thing. But I mean, I think the headline that emerged from the interview was one trainee only in the county of Mayo.
Yeah.
I mean, that's just, it beggars belief actually that is the case. And it is worrying. It means at a societal level, it is worrying. Well, anyway, today we're going to talk about the law of antiquities, kinda, and the repatriation and restitution of artefacts between countries. And somebody has something and says, well, I own it. And somebody else says, no, you don't own it. I actually own it. And states say, I own it. And other states say, you don't own it. And all that sort of stuff. And we have a brilliant guy here, a barrister, a recently qualified barrister, but he's been an archivist for a long time, an old pal of yours, Martin Bradley, and I'm really looking forward to that interview. And, he's going to tell us all about the Elgin Marbles, for example.
Yeah, and Egyptian sarcophagi and a lot of other issues between the two.
I'm going to have to get you to say that. Egyptian what?
Did I say a
sarcophagi?
A sarcophagus. Yeah, I hope I did.
As the man says, that's easy for you to say. Exactly. But anyway, there you go. All right. Well, before we get to that, let's have a look at 3 cases that you've identified from the Decisive website. The first case this week concerns an appeal from the Residential Tenancies Board over the blocking of a drain. This is very curious. In a residential property by coffee granules and foodstuffs by the tenants. So obviously they were flushing everything down the sink or whatever it was. And the blockage cost €88,000 to free up. Wow.
That was the evidence, yeah.
The drain doctor got well paid for that one. And the Residential Tenancies Board has a statutory maximum of 20,000. So there was 88,000. They can only award 20,000. Square that circle.
Yeah. Well, so as you said, it's an appeal from the Residential Tenancies Board. The case is the Web Summit Services in the Residential Tenancies Board. So it's important to say that residential tenancies almost all get determined by the Residential Tenancies Board. So even though the occupant here appears to have been a limited company, I think it was being used for their staff or for residential purposes. But what happened was that the landlord here found that the drain was blocked, and it was blocked by coffee granules and foodstuffs. And generally speaking, the landlord is responsible for the repairs in residential tenancies. Except where the use is what they call non-normal wear and tear. As you said, it cost $88,000 to repair this particular problem, so it wasn't a small issue. The Residential Tenancies Board awarded the statutory maximum of $20,000. It went on appeal to the High Court, and the High Court said that they were satisfied that the use of the drain for disposing of foodstuffs and coffee granules amounted to non-normal wear and tear, and therefore upheld the determination of the Residential Tenancies Board.
But they didn't get the other 68,000.
No, because that's the statutory maximum. They would have had to go. They would have had to bring some kind of negligence case.
Yet another lacuna in the law. Okay, let's move on now to criminal law. The second case today is an appeal from a murder conviction. This was a very distressing case of a stabbing of a woman on her way home from a cleaning job. How horrific is that? One of the issues concerned a telephone call she had made to her husband after the attack. The accused claimed that this should not have been admitted in evidence before the jury. Why was that?
So generally speaking, the rule of hearsay is that out-of-court statements shouldn't be admitted to prove the truth of their contents. an exception, which generally speaking, one comes across when learning the laws of evidence. One of the exceptions to the hearsay rule is what they call a dying declaration. And this is where what arises, where a person who has been killed, who is the victim of a homicide, says something factual about the circumstances, and that can be admitted in evidence. And this is where the general test is that they have a settled expectation of death. And so in this particular case, this poor woman who was stabbed on her way home in the IFSC made a phone call to her husband and told him some things about the murder. And in the course of the conversation said repeatedly that she thought she was dying. And on those grounds, the court admitted the statements into evidence.
Very distressing. And I should say that's the Director of Public Prosecutions versus CC, and that's a decision of Ms. Justice Tara Burns.
Mr. Justice Paul Burns.
Paul Burns. I saw the Burns. Okay,
and I think
two Burns on the Court of Appeal.
And I think it's also worth saying that the reason that the CC is anonymised is that the accused was a minor at the time of the attack.
Okay, so just really distressing case there. Okay, finally, we take a look at a case where the Gardaí refused to give a gun licence, having sought advice from the ballistics section in the Phoenix Park, I presume, which had emanated from this request. The applicant claimed that they had fettered their discretion, which is a legal term in judicial review, which you might explain, in seeking such advice.
Yeah, so this is an application for a gun licence. It appears to have been a slightly unusual gun that was being sought. And so the Gardaí, who, you make the application to your local Garda station. The Gardaí in this case obviously had concerns about the firearm in question, and they sought advice from the Garda ballistics section, and having received that advice, decided that this was not an appropriate gun to be licensed in Ireland. So the grounds for judicial review was effectively that they had fettered their advice by going to the ballistics section and saying, well, should we allow this gun in or not? And the court, not surprisingly, I think, said that this was a perfectly appropriate thing for the Gardaí to do, and that the advice, they were not bound by the advice from the ballistics section. But it was obviously...
I'm thinking of that Michael Moore scene in that movie, Bowling for Columbine, is it? Yeah. Where he opens an account, and as an incentive to open an account, they give him a gun. Do you remember in the bank?
Yeah.
I'm just thinking this is crazy. If the guards say, don't give this guy a gun license, I mean, how can the High Court even think about trying to overturn that?
I think the High Court didn't have to think very long.
No, not very long. Okay, and that is the case of Brennan versus the Superintendent of the Kildare Division, and it's a Court of Appeal decision of Mr. Justice Brian O'Moore. Okay, back shortly with Martin Bradley, barrister stroke archivist.
Silence in the Fifth Court.
So we are delighted to be joined in the studio today by Martin Bradley, who I should admit, conflict of interest. I worked with Martin several years ago when I was working as a historian and family researcher, and Martin was working as an archivist and records management in a company called Anaclan. Since then, Martin set up his own company called Archives Ireland and has worked as an archivist and records manager, as well as working for a number of museums and cultural institutions over the years. But just in the last couple of years, he has requalified as a barrister and is now practicing at the bar. So, Martin, thank you very much for joining us in the studio.
Thanks for having me, Mark.
And we are here to talk primarily today about the issue of cultural heritage and repatriation, issues relating to the Elgin Marbles, which we'll come on to in a minute. But maybe I can just ask you, after several years running your own business, working in archives and records management, what induced you to change your direction and become a barrister?
That's a really great question, Mark. And it's one that I've asked myself on a number of occasions over the last 4 years. I suppose the first point, when you mentioned we've known each other for several years, I think it's closer to a quarter of a century ago that we were working together. But I suppose, broadly, that there were kind of two things which encouraged me, I suppose, to look at requalifying as a barrister. One of those was, I suppose, an awareness of maybe a lack of specific legal advice that was available to people working in the GLAM sector. So GLAM is an acronym for Galleries, Libraries, Archives and Museums. Which
a very
obviously,
appropriate acronym.
Well, absolutely. It's nothing but glamour, as you know.
Right. So can you just say that again? Galleries, Libraries, Archives and Museums?
And museums.
Okay.
The GLAM sector, as opposed to the STEM sector. Sure. So I was interested, obviously, because having worked in the sector for almost a quarter of a century, I felt that I suppose I had a broad understanding of some of the issues that people working in the sector would encounter. And I wanted to be able to, I suppose, provide proper legal advice and maybe fill something of a vacuum that existed. And then I suppose the other reason was kind of the more broad midlife crisis type motivation, where you wonder if you're still able to study and pass exams and do those kinds of things. So I was encouraged by some friends who are at the bar to pursue that route. Sure. And I was equally given dire warnings by other friends who were practicing at the bar that I was under no circumstances to do it.
I won't say which camp I fell into there. But so obviously, I mean, I suppose the work of an archivist and records manager, you were very affected by issues like freedom of information and data protection. Is that a large part of what leads companies to use the services of somebody like Archives Ireland?
Interestingly, when the freedom of information legislation first came along, there was an expectation that this would result in a massive overhaul of how records management was done within the public sector. And obviously, there are requirements for bodies which are scheduled under the FOI Act, which is basically anybody who receives any form of state funding, that they would produce something called a publication scheme, which was supposed to contain a description of the classes of records that they have. And, the exact wording is giving such particulars as are reasonably necessary to facilitate the exercise of the right to access. As it turned out, the interpretation of the particulars that are reasonably necessary fell somewhat short of what people were expecting. So that this kind of turned into a very broad description of the types of records that people have. There's also, various exemptions within the Act in terms of the bodies providing access to the records. So, for instance, if the number of records that needs to be looked at is liable to cause a substantial and unreasonable interference with or disruption of their work, they can refuse a request. And similarly, there's a bunch of exemptions for things like commercially sensitive material.
So I understand from what you're saying that basically there are a lot of state bodies who might have been expected to do a really thorough overhaul of their records, but actually they haven't done so, and ultimately it's turned out under the legislation they haven't needed to. Is that a reasonable summation?
Yeah, I mean, I think it's probably, it would be unfair to say that they haven't addressed the issues, but maybe the extent to which some of those areas were required to be addressed under the legislation maybe fell short of what people were expecting at the time.
And then what about data protection? Does that make a difference?
Yeah, I mean, data protection, again, it's interesting in that there are specific exemptions that relate to archives. So obviously, under the GDPR and the 2018 Data Protection Act, you can make a data subject access request. But, section 61 basically allows an exemption for processing of information in the public interest and specifically by archives. And similarly, the ability of members of the public to make requests in relation to their personal information and to seek, rectification or clarification of the reasons why that's being held and processed. There are exemptions for archiving in the public interest, which is obviously the majority of our clients.
The impression you have on a day-to-day basis is that data protection is used more as an excuse not to release a record than to release a record. So that, whenever you hear, well, why isn't this available? Oh, because of data protection. I mean, is that... sometimes I think that's just used as an excuse because people haven't looked at the legislation. But is that a fair summary?
You see things like, say, the putative National Centre for Research and Remembrance, which is going to be basically the centre for people who've been through industrial schools, orphanages. And in a lot of cases, these institutions were run by religious orders. So they were effectively contracted by the state to care for people under a contract. But what that means is that their records are not covered under the National Archives Act because it's not specifically mentioned within the terms of the Act. And a lot of these institutions are basically, refusing to release these records on the basis that they contain personal information, citing the GDPR.
There would seem to be a simple enough way of kind of rectifying that problem. Can we not amend the legislation? And it seems like a huge lacuna in the law.
Yeah, we can. And I was working recently with the National Archives. So I produced a report which was an analysis of comparator jurisdictions looking at the legislation they have around record keeping. So, for instance, this issue cropped up in Scotland recently with effectively the same set of circumstances. But the Scottish legislation has been amended in that any third party which provides these services under contract to the state, their records are effectively state records. So this is something which could be addressed by a revision of the National Archives Act, but it hasn't been the Act itself dates from 1987 and the last revision was 2003. So it probably is due an overhaul. So I don't think state bodies have been remiss in responding to requests to provide the material. But I think that there was an expectation that there would be a massive overhaul in the way that records are kept within the state. And obviously that has a financial and administrative burden and implication, and that hasn't really come to pass.
And presumably that means that in relation to a lot of government departments, there are records that might be available for freedom of information, but simply can't be found because they're in archives that haven't been looked at for decades.
Right. And also that, the amount of work that would be involved in looking through that number of records is viewed as being, disruptive to the everyday work of the organisation. Yeah. I mean, you're probably familiar, you may remember from your previous work, your previous life as a historical researcher, the Land Commission records are one of the big ones which constantly get mentioned.
Yeah.
But is that? I'm sorry, I'm coming in here, and I'm a complete stranger to all of this. This is fascinating. This is an education for me. But I mean, is that good enough? If I say, look, I want to obtain certain records that are held by a state department, and they say, oh, you know what? We haven't got into that room in years. We don't really know what's in there. So sorry about that. We can't do this for you. Is that acceptable?
I mean, it really depends on what it is that you're looking for. I mean, in some respects, the onus is on the person requesting the information to have an idea of what the information is that they're looking for. So, the idea of the broad fishing,
I get that.
The fishing expedition going, I want all records that
that's fair enough.
X. I mean, there have been cases, for instance, with Force, where they basically provided all of the records that related to the training schemes that they were running and just dumped boxes and boxes and boxes into a room, which were then gone through by journalists. And then that resulted in some of the news coverage that came out about Force and its subsequent rebranding as Solace. So it's kind of a double-edged sword from the perspective of the organisations, because obviously the more intellectual control you have over your material, the more likely you are to be able to find things that are A, pertinent, or B.
So Martin, I'm kind of getting from you that what you're saying is that it's more kind of a benign obstacle, basically, rather than a kind of a deliberate attempt to conceal. There is obviously huge practical implication for, people going through all these documents because somebody on a whim says, look, can I have X? I mean, of course I understand that. And yes, I would have thought that somebody has to be pointed and specific in their request is very important and have reason to believe that something does exist, etc. So really, it's not like there's kind of false walls being placed as impediments to people.
Yeah, no, I think the word benign is really important here. And obviously, organisations like the National Archives do have responsibility for records which are transferred to them over 30 years. And that's actually been changed to the 20-year rule now. So the burden of responsibility on them is actually greatly increased. However, not all of the bodies which transfer records to the National Archives have staff who prepare the records or transfer them across in a timely manner or in the manner that would be useful to the National Archives.
So does that mean they're just handing over boxes and then one day they may or may not be indexed and gone through?
Or in a lot of circumstances, just not handing over records.
Yeah. Okay, well, we'd like to move on, but because the main reason we asked you to the studio today is that you wrote a piece in the Law Society Gazette in September of last year entitled Repatriation of Cultural Heritage. And it was the front cover story of the Gazette, and it was very entertainingly illustrated by a picture of Angelina Jolie in her Tomb Raider persona. They somehow omitted to have a picture of the author on the front cover. I can't think why. But the central theme of this was that there are certain items that may or may not have been looted or raided decades, generations ago, that may need to be repatriated, or the term you use a lot is restitution. How does this affect Ireland?
So in broad swathes, I suppose kind of working backwards from the most recent developments. So the most recent development was the Historic and Archaeological Heritage Act of 2023. So
that's Irish legislation.
That is Irish legislation, which it was enacted in October of 2023. And the significant thing within that piece of legislation was it allowed Ireland to accede to the UNESCO 1970 Convention, which is the Convention on the Means of Prohibiting and Preventing the Illicit Import, Export and Transfer of Ownership of Cultural Properties. And it also allowed Ireland to accede to the UNIDROIT Convention, which is the 1995 Convention on Stolen or Illegally Exported Cultural Objects. What these conventions allow, basically, is that the person who, believes themselves to be the rightful owner of an object can request its return.
I'm sorry, when you say person, is
well,
this
person,
a person
or
can that
state.
include a state? Okay,
Yeah, so it can be an individual or it can be items in state ownership. And obviously there are distinctions in terms of how it operates depending on whether it's a person. So the phrase restitution relates to returning an object to an individual. Repatriation relates to returning objects to a state collection.
Okay. And so in practical terms, are you seeing, or whether domestically or internationally, are you seeing more claims for restitution by individuals, or is it more claims like the Benin bronzes and Elgin marbles by states saying these were wrongfully taken during colonial times and we think they should be returned?
I mean, certainly a lot of what's getting popular coverage is the repatriation issue. And, you've probably seen this as still quite newsworthy. So the issue over the Elgin and Parthenon marbles. So these were taken by Lord Elgin in, I think it's 1801. Under a firman or permission from the then Ottoman Sultan, because at that point Athens was under the occupation of the Ottoman Empire, or it was part of the Ottoman Empire, depending on your viewpoint. And this was used as the kind of legal justification by Elgin to strip these marbles, bring them back to Britain. But
so sometimes it turns up in these discussions that people don't really know what the Elgin marbles are. But I mean, these are the statues that are from the Parthenon in Athens. I mean, they are a central part of Greek heritage.
From the fabric of the building.
Yeah.
And from, possibly the most iconic building in Greece and a key part of the sort of the Greek national identity and culture.
Yeah. And in fact,
was Lord Elgin not a purchaser for value, no?
Well, he was, the exact wording, I think, was that, hang on, let me find this, it's quite entertaining. The legal basis he was operating off was that he had a piece of paper which said that when they wish to take away some pieces of stone with old inscriptions and figures, no opposition be made. Now, if you were to rely on that as a purchaser for good value or good faith acquisition, I think it would be quite difficult. And similarly, it was controversial when he brought them back to the UK. There were parliamentary debates, and they were eventually purchased by the British Museum in 1816 under the British Museum Act. But they paid £35,000 for it. Which
to him or to his estate? Or?
To Elgin, which he claimed was about 1/3 of what it had cost him to remove them, pack them up and ship them to the UK.
Okay. And so do you know what the current state is of the litigation? And is that in the Court of Human Rights, or is it in the...
Well, so, the first point is the British Museum Act of 1963 explicitly forbids the British Museum of disposing of any of its holdings without an Act of Parliament. Under the 1970 UNESCO Convention, which the UK is party to, the Greek government listed the dispute in 1983 and formally requested that they be returned. This dragged on for years and years. In 2021, UNESCO called on the UK to enter into negotiations with Greece. They offered to mediate the dispute. The UK turned down this offer. The UK hasn't ratified the 1995 UNESCO Convention. Yeah. But, it seems that things have been moving onwards. So George Osborne, who's the chairman of the British Museum at the moment, has indicated that he is looking to find a solution to the problem. One of the solutions that's being put forward is that the marbles would be loaned to the Acropolis Museum in Greece, and in return for which things which have never been exhibited in the UK, such as the Golden Mask of Agamemnon, might have an opportunity to be seen in the British Museum. There was a bit of a spat quite recently involving Rishi Sunak, who got cross with the Greek Prime Minister, Kyriakos Mitsotakis.
Because he mentioned it in an interview.
Because he mentioned it in an interview. But in his defense, he was asked a direct question. And Rishi thought that he shouldn't answer this question because it was part of an ongoing negotiation. Yeah. So it's still a political hot potato,
but
200
but political
years.
Rather than legal. I mean,
well, that's the thing, because the UK hasn't ratified the 1995 convention. Okay. They're not beholden to it, but there's also a limitation.
It's only going one way, though, Martin. It's not. I mean, this they can only place their head in the sand for so long. I think.
Correct
on this one.
And also, you may have seen in the news recently there were other issues in the British Museum where it was discovered that 1,500 objects had been stolen by one of the curators, sold. And the reason why he was able to steal and sell them was that they weren't properly inventoried or catalogued, and also various pieces of Roman jewellery. It had jewels removed from them and were sold on. So the argument of the British Museum for years had been they are safer here in London than they are in Greece.
Are we whiter than white? I mean, if we're pointing the finger across the Irish Sea at our dear friends in London, I mean, how about Ireland? Do we have anything that anybody's looking for? What about the Hunt Museum down in Limerick? Wasn't there a bit of hassle about that?
I mean, the Hunt Museum is listed in Dan Hicks's book, the Brutish Museums, as possessing some of the Benin bronzes. The Hunt Museum previously was in the news because there were suggestions that maybe some of the artworks that had been acquired by the Hunts when they went on a shopping expedition in Europe after the Second World War, that the title in some of those paintings might not be entirely clear, but I mean, they
might have been
did
taken
conduct
from families that had been deported to camps, essentially.
This is the suggestion. I mean, they did conduct an internal review, and I suppose it's also important to state that I'm not suggesting that the Hunt Museum or the Hunt family are guilty of any impropriety. They did conduct a full investigation, and they didn't find any issues there. I mean, I think probably in Ireland, the slightly the more interesting thing, and the thing which is being addressed currently, is in relation to our ethnographic collections. So the figure, I think, was something like in 1860, 40% of the British Army was comprised of Irish people, and the Irish regiments were predominantly sent to colonial conflicts. So particularly in places like South Africa, Natal. So huge amounts of ethnographic material was sent back to Ireland, initially to the Royal Dublin Society, which then gifted its collections to found the National Museum of Ireland. And a lot of those materials were on display up until just post-independence. So the National Museum of Ireland was originally founded as an ethnographical museum. And ethnographical museums in the Victorian era were they had a semi-political basis in that they were intended to demonstrate the superiority of industrialized Western colonial society. And, the materials that were displayed were often displayed out of context, and they were really displayed as kind of war trophies almost. Now, post-independence in Ireland, obviously the appetite for the display of this type of material dropped off, and increasingly, I suppose, something which followed the narrative of, kind of Celtic history and, again, Irish, cultural nationalism. So you will see, say, within the National Museum, displays of bog bodies and Celtic art and church art.
And the Tara brooch and the Ardad chalice and those things that are more domestic.
Whereas all of these previously collected collections have been in storage for a long time.
But we do still display Egyptian sarcophagi and that kind of thing, which presumably, I mean, do we know whether those were purchased rather than looted? I mean, or what the origin of them were?
Yeah, I mean, again, this would be a question for the registration departments of the museums. So a lot of them do have very good records in relation to where they were purchased or where they came from. I mean, more broadly, there's an interesting question around deaccession. So a lot of people will have large collections, which they would probably be quite happy to see returned to the place that they came from, because they have no real, I suppose, pressing desire to display those materials. So, for instance, UCC returned an Egyptian mummy and sarcophagus to the state of Egypt recently because they were having to pay to store it in their basement. It was a slight embarrassment, and it didn't have any real scientific or research use.
So we're not talking about any great altruism here.
I mean, again, it's everything is a mixture of different
room to store.
impulses.
Can I ask you? Okay, this is not repatriation, but what about in our own dear Isle? Should we give the Derry na Flan chalice back to Tip? Or what about, more importantly, and this is something, and again, I'm very much an outsider here, gentlemen, so I hope I'm not, raising topics that don't merit being raised in the context of this discussion. But what about Inishbofin? Dear old Inishbofin and Trinity College retaining skulls from Inishbofin. They're not artefacts, but they're, culturally important, I would have thought, and Inishbofin wanted them back, and they got them back.
Correct.
What's going on there?
So, I mean, that was an interesting story. So effectively, they were taken from Inishbofin by a visiting academic from Cambridge who was conducting a study on phrenology. So obviously phrenology at the time was viewed as a sort of valid science, would not be so today.
For those who aren't aware, phrenology is the study of lumps in your skull and measurements.
The measurement of the sort of dimensions of the skull and the shape of your head with an attempt to then, I suppose, derive an understanding of, your level of intelligence and development. So again, this ties in very much with this sort of 19th century idea of the cultural superiority of Western society. But he found basically they were in a ruined church. There was a pile of, I think, 16 or 18 skulls which had been sitting there, which he bundled into a sack, smuggled off the island, conducted phrenological analysis on, and then gifted them to Trinity College, where they sat on a shelf within the medical department. This one is quite interesting because the people of Inishbofin obviously requested that they be repatriated, for want of a better word, even though Inishbofin isn't a nation state. It may seem like it when you visit there. But and I think, Trinity were divided on the subject, because some academics felt that, well, actually there was nothing to say where those skulls came from. They were just a collection of skulls that were above ground. It's not like they were exhumed. There was no real link to any particular time period. So, from analysis, they dated from, I think, between the 14th and 16th centuries. So how they got to be sitting there on the ground was subject for debate. And again, the idea was that, well, maybe they're better on a shelf in Trinity where they could be studied. Trinity put together a committee to look at questions of restitution and repatriation. It was their decision that they should be sent back to Inishbofin for burial. But I suppose within Trinity, this has then led into further issues that the same committee is examining. For instance, the Berkeley Library, which is now, or the library formerly known as the Berkeley Library.
There is a specific legal issue there, though, isn't there? When you talk about, I suppose, both the skulls in Inishbofin and Greek's Egyptian sarcophagi, because in relation to human bodies, there is no property in a body, but in relation to historic bodies, I think, and you go into this quite a bit in your Gazette article, there are particular issues in relation to dead bodies, presumably because they are, they are considered of very important cultural significance, and that if one country is kind of effectively looting the artifacts that are derived from people's bodies. And I mean, I think we were talking just before we started recording about the Pitt Rivers Museum in Oxford that had, certainly until recently, on display shrunken heads that were taken from other countries. I mean, what issues arise there in legal terms?
Yeah, I mean, there's the United Nations Declaration on the Right of Indigenous People from 2007. And basically what this makes is a distinction between what we might term to be anatomical specimens. So, elements of human bodies which are maintained for scientific research or historical research, and things which have cultural significance to indigenous peoples. So, for instance, they may form part of a belief system. It may be related to ancestor research, but the idea is that these remains are very much part of the kind of the culture and fabric of the country, and they're specific to a place rather than something which can have a life as a museum exhibit. So I think the key point there is that you have to respect the wishes of the people from whom those specimens were taken. But again, as with all these things, nothing is cut and dried. So, for instance, tattooed Maori heads are something which is kind of prevalent in a lot of museums throughout the Western world. And there was apparently a roaring trade within New Zealand among the native peoples selling these heads.
Right.
So collecting and selling them on to white people, and whether the tattooing happened post-mortem, but
Again, let's look closer to home. I mean, if you go down to a pub in Athy, I think it is, you will see the arm of the legendary Dan Donnelly from Donnelly's Hollow in the Curragh, who was heavyweight champion way back 200 years ago, isn't that it? If you look at it.
Oliver Plunkett's head with its severed ear in the cathedral in Drogheda.
Yes, absolutely. Absolutely. I remember as a child, we brought on a school tour up. We saw this skull, and I suppose we were expected to see a proper head or something, But anyway, there you go. Can I just ask you? I mean, this has been brilliant, Martin, and really, really informative, and really, I found this really, really interesting. But I'm hearing a lot about kind of United Nations conventions, and let's all do the right thing here, guys. Let's all sign up to this, and we should all behave properly. But nothing seems to be happening, really. Do you know? I mean, are we getting to the stage where the guards can come banging on your door? There'll be a court order saying, give it back, give it back and let's bring it to the boat and send it off back to wherever it's from in some other part of the world.
I mean, so under the terms of the Historic and Archaeological Heritage Act, as Ireland has acceded to the Unidroit Convention, the Circuit Court in Ireland has actually been empowered to hear requests for returns of items. And obviously these are subject to certain time limitations, and they're also subject to proper compensation being given to the person who has to return it, which is based on them being able to demonstrate that they were a purchaser in good faith. So theoretically, yes, you can bring a claim in court in Ireland looking for the return of an item. The key thing is it's within 3 years of having determined where the item is.
And that would apply to both private collections and public collections. So if somebody's grandfather or great-great-great-grandfather had come back from South Africa with one of the artifacts you're talking about, and they had it in their attic, they could in theory find that they were subject to an order to return it.
So in terms of the time limits, so it is, I believe, 50 years for an individual for a theft of an item. However, for something which is viewed as being culturally significant or has been removed from a national monument or from an archaeological dig or that has sacred significance, there is no statute of limitations on that. However, states can define it at 75 years or longer if they wish. So within the Irish legislation, there is a clause that says that the minister can set the period.
Okay, great. Well, we could obviously talk about this for a lot longer, but we've reached the end of our time. But we do have one question that we always like to ask our guests, which is, do you have any book or film that you would like to recommend to our listeners? Yeah,
I mean, I think I actually have it with me. And it's probably the best book to read on the subject of repatriation and restitution, which is a book called The Brutish Museums by Dan Hicks, who's a professor of contemporary archaeology at Oxford.
So that's brutish as opposed to British Museum.
Yes.
The Brutish Museums. Okay.
Play on words. And Dan is also the curator of the Pitt Rivers Museum in Oxford.
Fantastic.
So it's a very good book. It's been very divisive. Some people think that he's a raging Marxist. Other people think that his arguments are very well put together. Okay. But yeah, certainly worth picking up.
Brilliant. So Martin Bradley, thank you very much for joining us here on the Fifth Court.
The Fifth Court will adjourn until next week.
So that's all from this edition of The Fifth Court. We hope you have enjoyed it. Can we say a huge thank you to our guest, Barrister Martin Bradley, who talked to us all about repatriation of antiquities and artefacts and all that sort of stuff.
And shrunken heads and
Shrunken
skulls.
heads. Phrenology. I didn't know what that was. You seem to know. Our producer knew as well. I'm amazed. But what a fascinating interview.
We have a very widely read producer.
Yes, very widely read producer. Well, that we know anyway, Cunnell. Absolutely. Okay, so can we say a thank you to the said Cunnell O'Morine for his assistance in putting this podcast together, and a huge thank you to Lee Brennan who recorded this podcast. So from me, Mark, I'm going to say cheerio.
Yeah, and for myself, Mark Tottenham.
And we'll see you soon in the Fifth Court.